It's all about it's all about protecting your legacy and securing your loved one's future. So once again, without much ado, I'll let Levin take us through the session. At the end, we'll share with you how we're going to move on from here for the next 4 weeks. Thank you very much. Over to you, Lavin.
Okay, thank you very much, Pastor, and good evening, everyone, on this very warm evening. I hope you've been enjoying the weather today. I know I have tried my best, but even as I'm sat here, I have a fan blowing on me because the evenings are still warm. It's not necessarily much cooler in the evenings, but we'll try and get through this as quickly as we can, knowing that you're probably all quite hot and sticky and they probably want to still enjoy the evening out there. So as Pastor said, we're looking at estate planning and funeral plans, and this is an area that's really important, but one that sometimes people overlook or procrastinate and hope that I will get round to doing this tomorrow. And of course, sometimes tomorrow never comes because you either lose capacity or you actually end up dying and leave your loved ones in a position of having to pick up the pieces. Sorry about that. Someone's just gone by on a motorbike, if you heard that. So, we're going to be looking at two topics and one journey this evening. The first one is estate planning. I will talk about LPAs, wills, and inheritance tax generally. And then I'll hand over to Pastor to talk about funeral plans. And he's actually got a case study as well to share about someone who hadn't put a will in place. So, in brief, estate planning is looking at everything you own and deciding who gets what, and that all depends on the plans that you put in place. So you can be proactive in determining how whatever you own is passed down or bequeathed on your death. And of course, a funeral plan is all about paying forward the cost of something that is inevitable. So, in terms of estate planning, the areas we're going to look at are lasting powers of attorney, wills, how you can put your property into a protective property trust, mitigating inheritance tax, and the impact of pensions in terms of that being included in estate planning. So, there are three things that you can do and should do to take control of your assets during your lifetime and on death. The first one is to arrange your will. It can be a simple will if you don't have many assets, especially if you don't own property and you're renting. It can be a simple will, or you can do a more complex will, which includes putting property into trust, and I'll cover that later on. You might look at gifting during your lifetime. There are certain gifts that are exempt on an annual basis, and if you were to use that during your lifetime, not only does it reduce the value of your estate by the time you get to death, it also drops out of the calculation for inheritance tax. So again, that's really important if you can afford to gift to do so during your lifetime. And then we're looking at creating a legacy fund. And basically that is putting any life insurance that you have or life assurance into trust. And that ensures that when the life assurance pays, it doesn't fall into your estate to push the value of your estate maybe into the band where it would incur inheritance tax. So we're going to go through each one and we'll talk about the benefits of doing so. So lasting powers of attorney is more important than a will. Why? Because a will decides what happens to your assets when you die, but power of attorney decides how you and your assets are managed if you lose physical or mental capacity before you die. Now, there are two types. There's a property and financial affairs and a health and personal welfare LPA. Now, the property and financial affairs is, as it states, it allows your attorney to manage all of your financial and property affairs at any time with your permission. So with this one, you do not need to lose capacity, mental or physical. But let's say you're an elderly person, you can still walk, but maybe going to the bank is a bit of a chore. You're not really good on online banking, although most people do it that way these days. You can register your property and financial affair LPA with your bank, allowing whoever you've nominated to be your attorney, be it your child or a close relative, or maybe a friend that you trust very well, that they can handle those affairs on your behalf. And that would include maybe if you decided that your property was too large and you wanted to downsize to maybe a bungalow that would be more suitable, they also could approach an estate agent on your behalf to start the process of selling your property. So that's the legal permission that you would give your attorney to manage your property and financial affairs. Now, without this, even your spouse cannot act for you if there are assets that are solely in your name. So if the property is a joint property, they would still need a lasting power of attorney in order to determine whether your part of the property could be sold if you lost capacity. If it's a joint bank account, again, any direct debits that might relate solely to your requirements, again, would require a property and financial LPA for your spouse to be able to act on your behalf. And of course, if you have investments that are solely in your name, like an ISA or a general investment account, then again, your spouse would not be able to do anything with that until death. So you might assume that your husband or wife can act on your behalf simply because you're married, but that is not the case when it comes to making decisions about how your assets are managed. Now, when it comes to the health and personal welfare LPA, this covers any medical treatment, care arrangements, and personal welfare decisions, but this can only be invoked once you lose mental capacity. So the first one, you don't have to lose capacity. The second one, it can only be utilised once you've lost capacity. Now, I've got lasting powers of attorney for my mother. She's 95. She has dementia. So I manage both her property and financial affairs and her health and personal welfare. Now, one thing that she required was that she would not be placed into a care home. So although we have a social worker involved in my mother's care, at no point can they force the decision for my mother to go into a care home, because I've made the provisions for her to have a personal assistant that lives in with her. Now, if she didn't have that and social services deemed it important that my mother was placed into a care home for her own well-being, then they could actually force that because they would have the upper hand. So it's really important to have these things put in place before you lose capacity, because once you have lost capacity, you can no longer put in place any lasting powers of attorney, be it a property and financial or health and welfare for LPA. But make sure you choose responsible, trustworthy individuals who are over 18 years old and living in the UK. So it's no point nominating a brother or a sister or a child that lives abroad, because if they need to make decisions on your behalf, especially if it's concerning your wealth, with a time difference and delays, it could be, detrimental to your health and probably financial well-being as well. Now, decisions can be joint and several, which means that you don't need to have a consensus for a decision to be made. So typically you would have at least two attorneys on an LPA, and that's to ensure that the LPA can continue to function even if one of your attorneys was to die. Otherwise, if you only had one attorney, then when that person dies, your LPA has died as well. It's no longer valid. But if you have two individuals, and of course, there can be joint decisions, but you can also have it that only one person needs to make a decision instead of two. So it might be that you don't want every decision to be a unanimous vote or a consensus vote. I mean, for myself, it's myself and my niece, which is my mother's granddaughter, but I make most of the decisions without her, and she's happy for me to do that. And we do that for efficiency and expediency. So it all depends how you want to set up your LPA, whether you want it to always be joint decisions for your attorneys. And if that's the case, it always has to be a unanimous. So if you had 3 attorneys, 2 out of 3 would have to be in agreement in terms of, the decisions that they make on your behalf. So that's LPAs, and that's why you need them for while you're alive and if you lose physical or mental capacity. Now we're going to look at wills and why you need a will. So if you die without a will, your estate will be divided according to what they call the rules of intestacy. Now, the rules of intestacy are formula driven and in most instances rarely reflect what you may have intended for your assets. So if you have children and die without a will, they could be placed in care by the local authority rather than with your chosen guardians. So children under 18 without a guardian could end up in care. It might be that they'll still end up with a relative, but social services would have to do an assessment first to determine whether that relative is able to look after that child. If that relative was disabled or didn't have the financial means, it could mean that social services place the child elsewhere. But if it's already written into your will that your sister will be the guardian of your children, regardless of her situation, then that is what will happen with your children. So it's not only about how your assets are passed down on your death, but it's also what happens to your children under 18 years of age. Now, without a will, care costs can erode the value of your estate, and I'll talk about the property trust will. And one of the other fundamental issues is typically when you die, the spouse will inherit everything, especially if you have a joint property. Your spouse will inherit everything first before it passes to the children. Now, if your spouse was to get married after your death, it could mean that the new partner would automatically inherit everything, especially if a will hadn't been written, because once you marry, that annuls any will that you already have in place. So your husband or your wife could remarry, they then die, and the new partner inherits everything that you wanted your children to inherit. So again, if you have a will in place, you can put various trusts in place as well, which I'll talk about later, that would protect your children from any remarriage after your death. Now, without a will, creditors can make claims against your estate, and beneficiaries who may end up marrying and then getting divorced. So let's say you left your funds to a son or a daughter and they later on get divorced. Whatever you've left for them is now part of their estate. And when it comes to the divorce settlement, their spouse would be entitled to half of what's in the joint estate. So again, this is where having a trust in place with your will could prevent that from happening. Now, Pastor, you mentioned before that you had an interesting scenario of a sister that went to
Yes.
care for a sister. Would you like to come in at this point and just
Yeah,
tell?
just briefly.
Yes.
I was carrying part of a support group in the community, and I got to know a lady who was well into her 80s, and she had given up her own accommodation to come and look after her sister in her 90s. And she thought that was just the two of them that were alive. And unfortunately, the sister passed without leaving a will.
Mhm.
And there is something called the heir hunters
Yep.
who roll in whenever
Hmm.
a death is recorded. And if they find that there is a substantial estate, they go in speed to find potential relatives.
Yeah.
So this lady in her pre-90s suddenly found that there were relatives that she had never met and she did not know about in her 90 years, and they were
Wow.
entitled to a share of that estate, which left
Wow.
her homeless.
Yeah.
So these things do happen in real life.
Yep.
And it's one thing that we know from the beginning that the living will die. And so it's irresponsible to get to that age and you still haven't got a will or a
Exactly.
plan of what should happen to your estate.
Absolutely. And I'm sure had that sister realized what would have happened on her death, she would have rather left her home, her assets to the sister that was caring for her rather than relatives who she hadn't met, previously, and probably wouldn't want to leave that to them. So, that's a real life story of things that happen every day of the week where people fail to make a will. Now, it's worth saying a will is only valid if it's in writing and signed by the person making the will and in the presence of two witnesses. And one of the witnesses, or both of the witnesses, I should say, neither can be a beneficiary of the will or married to anyone who will be a beneficiary of a will. So if you're leaving
Yeah.
assets to your daughter or your son, it can't be their spouse who's a witness to the will. That will automatically prevent your son or daughter from inheriting whatever you've left in your will. But
Yes,
it's,
once again,
mm,
just as if I can
yes,
interject there, I was asked to be an executor to a will, and the wife had witnessed their husband's signature, and the husband had witnessed his wife's signature. And when it came to processing the will, that was null and void because
exactly.
she was a benefactor of that
Correct.
will, and she had witnessed her husband's will.
Yeah.
And as a result, we had to start all over from scratch as if there was no will,
Yeah.
and start searching for all of the relatives and writing to people that he might have known in the Caribbean
Hmm.
to see whether they had any interest
Yeah.
in the property. So that's how that simple thing of improperly signing
Exactly.
added all that complication.
Absolutely. If you don't do things the right way, even though your intention is to do it the right way, having a will, but if you don't sign it in the legal way it should be done, it's it's just something that's not worth the paper it's written on. But if you do things the right way, then a will allows you to decide exactly who your wealth goes to, the wealth that you've built up over a lifetime. Children under 18 years old will go to your nominated guardian for them. 50% of your home could be placed into a discretionary trust on death, but we'll talk about the protected property trust will afterwards. It could be protected from care costs if done correctly, and generational IHT can be significantly reduced where your assets are held in trust, and your beneficiaries could be shielded from divorce claims. So it's the opposite of what happens without a will. But it really is important to determine what type of will you need. So if we look at protecting the family home, the problem with mirror wills, what they call simple wills, is the home is held as joint tenants. So each person owns the home 100% each. Now, typically, everything passes to the survivor on first death. So if the husband dies, the wife owns everything. The full estate is exposed to care fee costs. So if the wife then needed to go into residential care, obviously the local authority could look at the whole value. Sorry, I don't know what happened there, how that switched on. Apologies there. Yeah. So if the wife needed to go into care, the local authority would look at the value of the whole property because she owns it 100%, just like the husband owned it 100%. And where there are claims against the property, creditors could make claims and it could fall into, a child's estate, a beneficiary's estate. And if your child is doing well in life, they have a good career, they may have a property or they may have assets that already puts them above the threshold for the nil rate band and the residence nil rate band if they have children. So you're just adding to their estate problems. Now, you have something called tenants in common and a property will trust. Now, this is a good option, but it must be drawn up before you could have suspected needing social care. Otherwise, it will fail under what they call deliberate deprivation of assets. Now, that is where a parent might give you the money or gift a house, whatever it is, knowing that later on they could end up into care. Now, the council aren't so, simple to think, this was a valid thing and it's just a parent wanting to pass their assets to their child, they do know that people try ways to dodge paying care home fees. So again, the council will be within their right to have a look at when the gift was made into the trust, and is this what they called deprivation of assets. So in this type of will, each partner will hold a 50% share separately. Now, on first death, let's say the wife passes first, her will stipulate that it will go to, 50% to this child, another 50% to another child, or whatever share that she wants to allocate. But on her death, her part of the property, her 50% share of the property will pass into what's called a discretionary will trust. And it will stay there until the surviving spouse then passes away. So the beneficiaries don't inherit straight away on the death of the first person, but what it does, it stays in trust, and the surviving spouse has a right to live in that property until their death. So the children could not force the remaining spouse to vacate the property so that they can inherit their share of it. The surviving spouse would have what you call an interest in possession in the property, which means the property cannot be sold until the surviving spouse passes away. Now, if for whatever reason the surviving spouse did need to go into residential care, the local authority could only consider the 50% share of the property that they own instead of 100% share of the property, which it would be if they were joint tenants and it wasn't held in a trust. The 50% of the first spouse dying didn't go into trust. So this is where it can be beneficial. But like I say, you have to be careful that you're not caught out by what they call deliberate deprivation of assets. Now, there are circumstances where the family home is protected without any transfer, and that's where the care first starts. Where care first starts, your home is ignored for 12 weeks until you decide what to do. So you've got this 12-week property disregard, and sometimes within that 12-week period, the individual going into care may actually pass away in care. So 12 weeks is 3 months. It won't be regarded within a 12-week period. Okay. The other bit is a qualifying resident. So if a spouse, partner, relative over 60, or a disabled relative lives in the property, it is disregarded entirely. The local authority cannot consider the property for the care home fees for the individual that's going into property. Now, there's also something called deferred payment agreements, and that's where the council can place a charge on the property and recover costs after death. So in that way, allowing the home to be kept during the person's lifetime. So it depends on what the local authority want to do and decide to do, but they could put a charge over the property, and then when the individual passes away, they would then reclaim any outstanding care home fees from the value of the property once it's sold. But like I say, if it's only 50%, then it's only that 50% share that could be taken into consideration. Now, how IHT works. So everyone is given a tax-free allowance, which is called a nil rate band. And the first 325,000 in terms of the value of your estate is taxed at 0%. So although it's exempt, it's classified as being taxed at 0%. Now, anything above the £325,000, if you're a single person, would be taxed at 40%. So it's only the amount above 325,000 would be taxed at 40%. If you are a single person and you have a direct descendant, i.e. a child, even an adopted child, that would count as a direct descendant. You then have an additional £175,000, which is called a residence nil rate band. So if you add that to the 325,000 as a single person with a direct descendant, where you're leaving the property to that child, your exempt band would be £500,000. So you would be able to leave an estate valued at up to £500,000 before it would be subject to tax at 40% above the £500,000 threshold. Now, if you're a couple, with children
That's
and you own property.
mm,
Was that a question?
No, go ahead.
No, sorry. Right. So if you're a couple that owns your own property with children that you will be bequeathing your property to your children, then that will be double the amount that it would be for a single person. So you would basically have £1 million that you would be able to pass down to your children before it would be taxable to inheritance tax. So as I've mentioned on previous seminars, living in London, it's probably not very difficult for the value of your property to push you closer to £1 million in terms of the value of your estate. And so it would be really important if you feel that you might be in that band, even if you're not there yet, but you feel that you are close to, and maybe in a few more years you could see yourself in that £1 million plus band in terms of the value of your estate, to start looking at estate planning now. And things that you could do to reduce the value of your estate are things like lifetime gifting. Now, there are certain amounts that you can gift each year that aren't included in the calculations. So there's an annual gift exemption per year of £3,000. There's also £250 to anybody. You can give certain amounts to your child or your grandchild for their wedding. If you look on the HMRC website, it's got all these different amounts that you can gift without there being any immediate or future tax liability attached to that. But it all depends who you give the gift to and their relationship to you. So gifts between spouses are always tax-free, but between parents and children, there could potentially be a tax liability. And it depends on the value of the gift. If it's below £325,000 and it's an outright gift, it's tax-free. And depending on when the gift was given, if it is more than 325,000, you would need to survive 7 years in order for there to be no inheritance tax liability on that gift at all. If you die within 3 to 7 years of gifting, there is what you call taper relief, where there is still an IHT payable, but it's reduced because of the number of years that you've got remaining to reach the 7 years. So instead of it being taxed at 40%, it might be taxed at 36% or 24%, whatever it is. But that would be reduced if you did not survive the 7 years, but you survived more than 3 years after gifting. Now, there are other gifts that you can make, and you can make those into what's called a discretionary trust. That's in the middle here. And that's a tax efficient way to pass wealth down the generations. Just like with the property, if it goes into a discretionary trust, it does not fall into the estate of the beneficiary, your son or your daughter or whoever you're gifting your assets to. And it also protects it from divorce later down the line. Should that happen, it can't be considered as part of the divorce settlement. But it's called a chargeable lifetime transfer, in that if the gift is more than 325,000, then the element above 325,000 would be subject to 20% inheritance tax immediately. Anything below that would not be subject to any inheritance tax, but again, it would take careful planning to determine when to move assets into a discretionary trust, because once you do that, with certain trusts, you may well lose control over that particular asset. But putting a property into a trust is tantamount to a discretionary trust. And the other one is life assurance in trust. Now, if you set up life insurance, most people don't think about putting it into trust, but when you work with a financial advisor, they will always recommend that you put the life insurance in trust, because anything that is paid into a trust on death stays in a trust and does not form part of your estate. So let's say your estate was worth 800,000, mainly your property, and you had life insurance for 250,000. If it wasn't in trust, the £250,000 would be paid into your estate. All of a sudden now, your value of your estate is £1,050,000. So the 50,000 would be taxed at 40%, which would mean that you'd end up paying 20,000 in inheritance tax. So again, these are things that you can do to mitigate your inheritance tax liability. And that type of advice would come from working with a financial advisor. Now, when it comes to paying inheritance tax, it's normally payable 6 months after the date of the death of the individual. And it's payable at 40% if it breaches the nil rate band or residence nil rate band. If it's passed to a spouse, there is no inheritance tax on first death. But there are two different types of insurance that you could look to take out. Now, both of them will require what you call underwriting. So if you have what they call comorbidities, let's say you've got diabetes, maybe you've got high blood pressure, that type of thing, the insurance company will need to know about that in terms of the underwriting, and that will impact how much you pay in terms of the monthly premiums. And of course, it's only valid as long as the insurance policy is still in play. So let's say, you took out an insurance policy that ends at age 60 and you died at age 61. Clearly, no insurance is going to be paid out because the policy has ended. Also, if you're paying your premiums and all of a sudden you've lost your job and you can't pay your premiums, again, that would end the policy as well. So you need to make sure that once these policies are in place, you keep up with the payments of the premiums. Otherwise, if you default, and some insurance companies will allow you to default for maybe 3 months, but again, you'd need to contact them to tell them why. They can put it on hold, but only for a certain period of time. Now, if you've got a whole of life insurance, that's the type of insurance that you'll pay until death. It's whole of life. It's not term insurance, which is what most life insurance is. It's for a term of 20 years or 30 years. With a whole of life insurance, you will pay that for the rest of your life until you die. Now, the good thing about that is that you are guaranteed it will pay out on death. It is automatically written into trust. So whatever is received does not fall into your estate. And normally it's used by families to ensure that whatever is in the estate passes to their beneficiaries without the government taking their share. So once the insurance pays out, it normally, once you work with a financial advisor, it tends to match the amount of IHT liability that would be payable. So instead of the estate paying the insurance, the inheritance tax liability, it would be the payout from the insurance that would cover the inheritance tax liability, meaning that 100% of whatever you leave behind would go to your children or grandchildren, whoever you leave that to. The cash is ring fenced. So there's no forced sale, because typically what happens when inheritance tax is due, especially if it's due because of property, the value of property, is you have to find that money. So let's say it was due on a property worth 800,000 above the nil rate band, 20% of that, you're looking at 160,000, sorry, it'd be 40%. You're looking at £320,000 payable in 6 months' time. Now, not many families would have that money to pay to the Inland Revenue. But if you've got that payout from the insurance, you can use that to pay the inheritance tax. Typically, what happens where a whole of life insurance isn't in place, but the family might need to pay an inheritance tax liability, is that they can go to the bank with the death certificate, with details of whatever assets are owned, and the bank will normally loan you a certain amount against the property to pay the inheritance tax. Then once the property is sold, you would repay the loan, but typically you're going to pay interest on there as well. Now, the premiums will rise with age. So the older you are, the shorter the time you've got to live. So again, all these things are taken into account, and that will determine what the premiums are for you to pay. And they can be quite pricey, but again, because it's guaranteed to pay out, normally, the way these whole of life insurance policies work, you typically don't pay out the full amount that would be paid back on death. So it's more or less a win-win situation. With most whole of life insurance policies, you'd have to be paying it for 40 years plus before you end up paying the amount that would be due in terms of the inheritance tax liability. So a really good way of ensuring the tax gets paid and it doesn't come from your estate. Now, the other type of insurance, which is cheaper, would be a joint life second death policy. So it insures two people, husband and wife, and it pays out on second death. So this is purely for inheritance tax purposes. It's not to pay, the funeral of the first person that dies or to look after the second person that's remaining. It's paid out on second death and it's used to pay inheritance tax liability. The premiums are lower than whole of life insurance, and payout timing aligns with the tax liability. Again, you would set it up in trust because that's the most tax efficient way to do that. And with both of these types of policies, it provides liquidity at just the time when you need it. It preserves the value of the assets, so it all goes to the beneficiaries, and it can be reviewed regularly. So if you need to top up the liability because, the value of your assets have increased, you can do that. But typically, if the value of your assets were to fall because you've spent the cash that you've got, in the estate, you would still get the same amount paid out. So all that would mean is after the inheritance tax liability is paid, there's more left for your beneficiaries to use for their own purposes. So what's changing? In 2027, we know that pensions will form part of your estate for inheritance tax purposes. So again, something that you need to review. What's the value of your estate now? And what would happen if your pensions were to fall into your estate? Would that push you above the nil rate band and residence nil rate band? Now, both of those are only frozen until 2031. So yes, you have a bit of time until that happens, but beyond that date, they could look to reduce the nil rate band or continue to freeze it. If they freeze it, it just means more and more families' wealth gets caught into the inheritance tax bracket. Pensions from 2028, the minimum pension access age will rise from 55 to 57. So again, if you are wanting to take your tax-free cash, you're going to have to wait an extra year. So again, it's really important to look at the value of your pensions. If they were to fall into your estate, what would happen? And also when you can access those pensions. Because if those pensions are going to fall into your estate and you can't access them, it's going to add potentially to the inheritance tax liability. So these are just some things that you need to be mindful of. So, we've created an estate planning checklist. So what you need to do is create both LPAs, the property and financial affairs, and health and personal welfare. Do both and do them now. You can use a solicitor, which if you're not someone that's very good at filling in forms and making sure you sign them properly, I would highly recommend that you do that. Some financial advisors can do that. I myself can do LPAs. It's just a matter of going onto the internet, going onto the HMRC website, completing the form, make sure you complete it properly, printing it off and make sure it's signed in the correct order. There is a way that you should sign it. They do give you instruction details, but a lot of people tend to get this wrong. And I think on a previous slide, we were saying that 51,000 LPAs are rejected and sent back to be redone. And each time they sent back, you have to pay another £82 to set up the LPA and get them registered. If you go to a solicitor, it will cost you more than £82, but at least it'll be right first time and it'll be drawn up correctly. The other thing you need to do is to draw up a will. And if you do own property, consider whether you'd want to include a discretionary trust. Okay. Trusts come with their own complications, so it's not a be-all and end-all. Again, you need to look at your own individual circumstances to see whether a discretionary trust is the right solution. But in drawing up a will, again, best to speak to a financial advisor and a solicitor, and working together, they can make sure that you draw up the correct will for you. If you don't own any property, then simple mirror wills will be more than adequate. Okay. The next thing you need to do is to review your property ownership. Now, whether you're going to put your property into a property will trust or not, it's probably best to, using a solicitor, change from joint tenants to tenants in common, so that later down the line, if you did decide to do a property will trust, again, it would be easy enough to put 50% of the property into a discretionary trust, leaving the other 50% for the surviving spouse. Should they go into care, then that's the only amount that the local authority would be able to use as part of the assessment. Now, review your pensions. I'd say straight away, have a look at what the value of your pensions are, check if they're performing in line, and again, refer yourself to a financial advisor or a financial coach, someone like myself. I could have a look at that with you. and give you advice in terms of what you need to be doing. But it's really important that you update the expression of wishes that are connected to your will. If you don't have that in place, it will be at the discretion of the trustees to determine who to pay your pension to, whether it's a surviving spouse, might be someone that you're separated from. You don't actually want them to receive your pension. But if you don't have that expression of wish form, it could go to a surviving spouse where you're separated rather than going to your children. So again, review your will and determine who the pension will be paid to should something happen to you. Now start gifting and start getting advice. If you can afford to gift, gift to children, grandchildren, to reduce the value of your estate so that it stays below the threshold for your particular circumstance, whether you're a single person or a couple. But start gifting if you can afford to do so. And think about your funeral. Does your family know your wishes? How would it be paid for? And what's the financial impact? And at this point, I will hand over to Pastor Ndebele to talk about funeral plans.
Yeah, actually, I'm looking at the time and
Okay,
thinking that perhaps we should cover this as a separate topic. I tried to squeeze, last time we did it as two separate topics.
we did.
So I suggest we take some questions and
Okay,
we table the funeral plans for
yep,
another session.
that's fine. Sorry, I
So
didn't realize the time had gone.
before we talk about take some questions.
Yes,
Perhaps you could say, you know, for everybody, Laverne is committed to these 6 sessions that we've done together. So today would be her last one. We want to thank you immensely for your insights and for your knowledge and for the time you have voluntarily taken to support us here.
you're welcome.
So,
Yeah.
how can you continue to support these individuals? And if you could maybe scroll to the slide with your information.
Yep, okay. So I don't know if you can see this slide here.
Yeah, yes,
Yep,
thank you.
but that's got my details here. And what I would be willing to do is to do a free half-an-hour consultation with anybody that would like me just to review um, their personal finances, basically how they're set up, property, no property, pensions, etc. And then if you wanted to go forward with some coaching, then it would be a paid service after that. But the first 30 minutes would be free of charge. So if you do
Okay.
want to contact me, there's my email address and my mobile number, and I can definitely coach and give you some pointers in terms of where you should be focusing.
Okay, that's awesome. That's fantastic.
Yeah.
So 30 minutes of free